Thank you, Peter. Peter and I have done similar presentations like this before on this DME topic, and I'm sort of like the bear cub or the bird in the sky that comes in after he is done and spent all the time on all the topics and has eaten the entire carcass, and then I get whatever piddlings I can get. CMEs, DMEs, IMEs must be by court order. We've heard a lot about that, and we heard Steve talk about that too. I don't spend a lot of time on the good cause requirement just because the judges, if you've got a personal injury case, for the most part, they are going to allow the DME. The main thing that Peter touched on is to get the stipulations. Again, they must have a court order to have a DME. Yes, we agree to them, but they must have a court order if they don't agree to our stipulations. And so you want to lay out stipulations in a letter as to what is going to happen at the examination. And if they don't agree to it, then they need to get a court order. You know, some of those things that you want to have in the report, in other words, you want to have the report within a timely manner. A lot of times they're doing these things 2 or 3 weeks before trial. I want a stipulation as to when I'm going to get that report, or that doctor can't be used at trial. I want to make sure that they're paying for the report and that the report gets done. I want to go through the manner in which the examination is going to take place. If there's depositions and multiple reports in the case already from other providers, I don't think they need to take a history of the client. Again, I think the judges are not going to agree with you on that for the most part. I want to know precisely where the location is, the date it's going to be. I want it to be on my client's time, not some time that they've given me in a letter. I want to talk about recording, and I want to talk about attendance of an attorney at the examination. And if there's a concern about whether the attorney is going to become a witness by going to the examination, make that a stipulation too. I don't really have much concern, and I'll get to that later. Non-ORCP 44 exam, the PIP exams. For the most part, those are becoming pretty routine in auto cases. How many of you just routinely send your clients, you know, to the PIP exam because you got to continue the benefits? How many? Pretty routine. You got to continue the benefits, send them off to the PIP exam. What I'm here to tell you is you need to weigh that very heavily. You can't just send your clients to the PIP exams anymore because their benefits are going to be denied for the most part. How many of you in the room have sent your client to a PIP exam and you came back with a pretty good report? Well, there's a few of you. I don't get too many good reports. I get a lot of bad reports. And how many of you are getting requests for PIP exams within 3 or 4 months of the injury? Okay? And you get a lot of bad reports. You know, for the most part, your case is over after the PIP exam. Unlike Steve Hendricks and Rob Wolf, who don't settle cases, I'm just a mere mortal that settles cases. And if the third-party carrier or adjuster has a bad PIP IME, they can use that against me, and they do use it against me, even if they don't say so. Why should they be telling their boss or supervisor to pay out big on this claim when some medical provider of the insured's own company is telling them there's no injury or there's minor injury? So you may have a good case, but 3 or 4 months into it, you've got a doctor already saying this person doesn't need any more treatment, or he needs 2 months more treatment. So you may have a serious injury, and 6 months into it, you've got a report in your file, and the defendant will eventually get that report that says that your client doesn't need any more treatment. So weigh that decision very heavily. And I think the same stipulations apply for an IME exam. You need to be there sometimes, or send somebody there to make sure you know what's going on at that exam. My dream is that, like in California, not only are you allowed to record, and and not only are you allowed to attend, but you can videotape. So at trial, I want a videotape. I want Troy, Moody, and Nagley to videotape that thing so that at trial I can compare the report with what actually happened at that IME. In some cases, that's going to be very helpful to you, because some of these guys, believe it or not, and gals, don't tell the truth, these doctors. And Peter talked a little bit about the olden days. I think back in the olden days, where a judge assigned a doctor to examine the plaintiff, then it was pretty fair. I mean, you might get a bad doctor or a good doctor, but the judge has appointed the person. Nowadays, when people are getting paid to do these, doctors are getting paid to do these by one side, how can it possibly be objective? When these doctors, a lot of them, are making $700,000 or $800,000 a year doing these exams for insurance companies, how can it possibly be objective? So the older cases in Oregon where there was the Pemberton case, where there was even a statement that, you know, these are non-adversary proceedings, these IMEs and DMEs, we all know that's not the case anymore. The majority of jurisdictions, and I did a little mini analysis of cases across the country, do permit recording and attendance at IMEs/DMEs. We all know that there's a cottage industry. I talked about the doctors, but the biggest cottage industry are these companies that put up these doctors or have these doctors on their payroll, and they put them up for the insurance company to do the exams. Particularly in the PIP context. The insurance companies and defense lawyers like to deal with the companies as opposed to the doctors. Sometimes they do contract directly with the doctors, but not as much anymore. These are million and billion-dollar companies that all they do is examinations for insurance companies. So you need to pursue that issue in cross-examination too. The reports that are done, a lot of these review companies have nurse practitioners or nurses that kind of set up the case for the doctor. Those, by time it gets to the doctor, the decision's pretty much already made as to what that doctor's going to say. We have the Foltz case where folks other than the doctors were even signing the reports for the doctors. They don't do that anymore. They've gotten a little bit smarter, but in essence, the reports are done and prepped for the doctor and ready to go. And if you look at a lot of the doctors' reports, you see the same faces. You look at their reports, same paragraphs. You know, make those comparisons. Multnomah County motion panel consensus statements, they're not rulings, whatever they tell us. On this DME issue with respect to recordings and with respect to attorney attendance, I'll give you a little bit of history. Way back in the year 2000, we could not attend DMEs. Couldn't do it. That was the Multnomah County rule, and that was what was followed. And you couldn't record back in 2000. In 2000, the motion panel reversed its decision because plaintiffs' lawyers submitted a bunch of materials and defense lawyers submitted a bunch of materials to the panel, and they were going to decide which way they should go on it. What they did is they just reversed the rule and said, we're not going to exclude attorneys, we're not going to say no recordings, but we're not going to say one way or another. It'll be on a case-by-case basis. And what they wanted to do was wait and see what the decision of the Council on Court Procedures was going to be. The Council had taken this up, and it was a major issue for the Council back in 99, 2000. And the Council of Court Procedures is a group of plaintiff lawyers, defense lawyers, and judges that make changes to the ORCP. And that, in that committee, it was pretty much done that they were going to make the change that permitted attorneys to attend and permitted recordings. Unfortunately, it got sidetracked, and the Council of Court Procedures requires a supermajority of 2/3, and they fell one vote short. They needed 15 to pass it, and it would have been the ORCP law. They had 14 votes and needed 15. What the Multnomah County panel did, though, is they kind of split the baby. They said, okay, we're going to allow recordings, but we're not going to allow attorney attendance. So what in effect they did, even though the majority of the council said we should have both attorney attendance and we should have recording, they decided that we're not going to have attorney attendance. So basically what they did, they said, well, let's wait and see what the Council on Court Procedures says. Council on Court Procedure and a majority said we should have both, but they didn't follow it. They split it so that now in Multnomah County you can get a recording, but you need to make some kind of a showing that attorney presence is necessary. And I've tried a couple of times, and they're pretty adamant that they're going to follow their local rule, which they say is not a local rule. Yes? I believe it does. They don't want other people there, not just the attorney. Yes, that's a good point. I have a long list of about 25 things, and you can agree. They usually agree on 10 of them, and then you decide which ones you want to argue about. I try not to argue about all 15 of them because then they throw that up in front of the judge. I try and make my 2 or 3 main points that I want to get. The couple of cases that I think are important, one is the TriMet case, 308 or 185. And in that decision, the Oregon Supreme Court reversed the decision of the Court of Appeals and reinstated the board's award. This was a workers' comp case, but I think you can use this case. The Oregon Supreme Court found that the insured's insistence on having an attorney present when he was examined by a designated physician but did not constitute obstruction of medical examination requiring suspension of insured's rights to compensation. In other words, they wanted to suspend because the attorney was going to be there. In rejecting the lower court's assertion that the presence of an attorney might affect the neutral setting and the objective environment of an independent medical examination, the court quoted the referee, "I do not find much merit in the objections raised by the proposed examiners in this matter. Claimant's attorney has agreed to do nothing more than observe. The examiner's suggestion that attorney's presence would taint the examination is patently absurd and only bolsters concerns over examiner objectivity." I think that needs to be read to some of the judges in Multnomah County.
Are you sending observers or trying to record PIP IME?
Sometimes I do. They will oftentimes object to that, and so then the issue is, do you want to deal with them cutting off your PIP benefits, cutting off your client's PIP benefits at the IME? But my thinking is, I'm not sending many people to IMEs from the PIP carrier. I would rather just have my benefits cut off if I can in that particular case, talk to the medical provider, try and get the medical provider to continue treatment anyway. Sometimes folks do send because they just feel like they have to. They don't want to be, the attorney does not want to be responsible for cutting off their benefits. But given the percentage of cutoffs anyway, I just have a hard time sending them. Bill? You're right. You can't just tell your client, me attorney says don't go. But you can be pretty persuasive with your client.
Are you having any trouble to do that sometime with the Blue Cross or some other medical providers saying, we don't have an exhaustion limit here, so why are you paying for this?
I've seen that before too, and then you do have to fight that battle, but the bottom line is that they're secondary, and if primary is not paying, then they're supposed to pay according to their contract. I don't know that it says anywhere in their policies that you have to go to quote unquote and from our perspective, a biased medical exam to continue your benefits. Yes.
You mentioned that try to get the other side to get a court order to get these DMEs, and in there you try to get certain your 2 or 3 main points to be ordered. Have you been successful in having the judge order this to get financial information? The DME, is that one of the things they do together?
Yes, and recently, Judge Jones, who was doing a lot of these expedited motions, 2 cases right in a row, ordered that they had to give some financial information.
And everybody, of course, is sharing that information with all of us, so we can all have it.
Correct. That's the way it's supposed to work.
And my other question is, are you also successful in limiting, when the other side says it's an issue of contention, you got an X-strain case, and it lasts more than 8 weeks, so they assume, of course, that only Dean and Hines can evaluate this person's condition. Or, I'm sorry, I just forgot the name.
Should they have psychological problems if they're treating after 8 weeks?
Right, because after 3 weeks, they decided an issue is a mental condition that you've never played. Can you keep, will the judge's order to keep that from happening?
To keep the psychological...
To not have the psychological DME as part of the panel, because you've never alleged it?
I don't know. I would think, if it's not in your complaint, why are we sending somebody to a psychological DME? But then there's some judges that believe, there's emotion in psychology in every injury, and therefore you've got to allow for that DME. But I think you can make some pretty strong arguments. I haven't really dealt with that. You guys, you're into your break time now. Say that again, I wasn't listening. I'm asking her what she said. Okay, so Judge Jones ruled that if you're claiming physical injury only in your complaint, and they are requesting a psych exam, he was not going to allow the psych exam. How's that, Peter? Okay, I'm going to quickly wrap up here. Keep in mind that DMEs and IMEs, particularly in auto cases, in my opinion, is the most important procedure in the case. In most of these auto cases, we don't take them unless liability is pretty certain. So the issue is injury. So the most important procedure is a PIP exam that may kill your case right out of the chute, or an ORCP 44 exam. Would you send your client to a deposition unrepresented? Peter thinks that maybe you become a witness. How many of you have become a witness because you attended the deposition with your client? Tom doesn't like that analogy. But that's the kind of argument you've got to make. California has had attorney attendance for years. Washington has had attorney attendance for years. Attorneys in Washington and California do not become witnesses because they attended the examination. And so long as you got a recording too. Keep it recorded. Why shouldn't you be allowed to attend? As I said, the PIP case can blow up in your face from the beginning. 90% of our cases settle. The examinations are important even if you think you're a great cross-examiner and you can kill the DME doctor at the end. Thanks.